We'll hear argument first this morning in case 21-328, Morgan versus Sundance. Ms. Gilbride?
Mr. Chief Justice, and may it please the Court, Section 2 of the Federal Arbitration Act requires that an agreement to arbitrate be enforced unless a generally applicable contract defense renders it unenforceable. But the Eighth Circuit didn't apply a generally applicable contract defense here. It applied an arbitration-specific waiver defense that requires the person asserting waiver to prove prejudice, even though prejudice isn't required to establish waiver of other contractual rights in Iowa. That's what the Eighth Circuit did wrong, and that's why we're here. But there's been a lot of discussion in the briefs about Section 3 and default, so I wanted to quickly explain what the Eighth Circuit should have done instead. First, it should have assessed Robin Morgan's waiver defense under generally applicable Iowa law to determine if there was an enforceable contract on which the procedural provisions of the FAA could operate. If it found waiver under state law, that would have been the end of the inquiry. If it found no waiver,
We'll hear argument next in case 21-248, Berger against North Carolina State Conference of the NAACP. Mr. Thompson.
Mr. Chief Justice, and may it please the Court, North Carolina law designates the state as necessary parties, the petitioners as agents of the state, and as necessary parties in all actions challenging state statutes. When such actions are filed in state court, the petitioners are defendants and necessary parties. This lawsuit, however, was filed in federal court. And when the petitioners sought to intervene, they were denied, and a strong presumption was applied against their intervention. This outcome should be reversed for two reasons. First, under Turbovich, we are entitled to intervene. The state respondents have candidly and forthrightly acknowledged that they have a primary objective in receiving clear guidance on what law, if any, will need to be enforced. And because that administrative responsibility and interest may not always dictate precisely the same approach to litigation as our interest in defending the law every step of the way, we are entitled to intervene under Turbovich. Second, this case presents foundational issues of federalism. This court recently in Cameron held there are deep constitutional considerations implicated when a federal court is called to pass upon the constitutionality of a state law. And thus a federal court must account for a state designating multiple officials to defend its sovereign interests.
We'll hear argument this morning in case 20-1034, Golan versus Sada. Ms. King?
Mr. Chief Justice, and may it please the Court. The Hague Convention provides that a court is not bound to return a child once the grave risk exception is met. The district court here, after finding grave risk to this child, was operating under an incorrect rule of law. That is, the Second Circuit's requirement that courts must examine the full range of potential ameliorative measures and return the child if at all possible. That requirement should be overturned for four reasons. It's not found in the text of the convention or its implementing legislation. It runs counter to the convention's purposes and framework, which emphasize expeditious proceedings, the safety of the child, and not getting entangled in custody matters. It's contrary to the long-standing views of the State Department, and no other signatory nation has adopted that interpretation of this treaty. If this court agrees with us, what remains is how best to resolve this case. In our view, a reversal is
We'll hear argument this morning in case 21-401, ZF Automotive US Incorporated versus Luxure Limited and the consolidated case. Mr. Martinez.
Mr. Chief Justice, and may it please the Court, Section 1782's text, structure, and history made clear that district courts are not authorized to grant discovery for use in purely private foreign arbitrations. The key statutory language is the complete phrase foreign tribunal. That phrase most naturally refers to government tribunals, just like the phrase foreign leader most naturally refers to government leaders. Ordinary and legal usage confirm that interpretation. So do nearby provisions using the same phrase, as well as this court's decision in Intel. The history supports us too. The Rules Commission drafted this statute under a direct command from Congress in the 1958 Act to promote interstate comity and assist the judicial and quasi-judicial arms of foreign governments. The Commission, Senate, and House reports all show that the drafters chose the words foreign tribunal to achieve these government-focused objectives. Luxshare misreads the text and ignores the context. It can't identify a single person, not a lawmaker, judge, lawyer, scholar, anyone, who ever claimed 1782 covers private arbitrations, either in 1964 or for decades afterwards. Luxshare's approach would flood district courts with discovery applications, undermine the goals of arbitration, and inflict asymmetric harm on American companies.
We will hear argument first this morning in original case 143, Mississippi against Tennessee. Mr. Coughlin.
Mr. Chief Justice, and may it please the Court. The Court should reject the Special Master's conclusion that equitable apportionment is Mississippi's sole remedy, because it's a remedy that redresses the wrong injury. Mississippi does not claim that defendants are taking more than their fair share of groundwater. Rather, Mississippi's case turns on a different question. Do defendants have the right to control groundwater while it is located within Mississippi's sovereign territory? And the Court has answered this question in Tarrant Regional Water District versus Herman. There, and considering an interstate surface river that had already been apportioned, the Court recognized an injury other than that of an upstream state harming a downstream state by taking too much water. Specifically, the Court recognized that one state may not divert water from another state's sovereign territory, absent a waiver of that sovereignty. And here it's undisputed that Tennessee is diverting groundwater from Mississippi without Mississippi's permission. And they do so knowingly. In the 1960s, the U.S. Geological Survey warned them it was happening. But rather than stop, defendants opened new well fields within 3 miles of the border and substantially increased their pumping. As of 2014, when Mississippi filed its complaint, they had suctioned more than 400 billion gallons of groundwater across the border. They've increased the cost of Mississippi's own groundwater pumping. And by their own admission, defendants' pumping is draining an overlying surficial aquifer that record evidence indicates is pulling contaminants down into the aquifer at issue in this case. Now, the Special Master, in reaching its conclusions, asked whether the Middle Claiborne Aquifer was an interstate resource. This was the wrong question to ask, because the answer doesn't matter. Even if the aquifer is an interstate resource, Mississippi still possesses sole and exclusive control over groundwater within its sovereign territory, as recognized in Tarrant and ensured by the Constitution. And defendants cannot force groundwater across the border without violating this sovereignty. I welcome the Court's questions.
We'll hear argument this morning in case 20-1530, West Virginia versus the Environmental Protection Agency and the consolidated cases. Ms. C.
Mr. Chief Justice, and may it please the Court, in Section 111 of the Clean Air Act, Congress directed EPA to partner with the states to regulate on a source-specific level, which means identifying measures particular buildings can take to reduce their own emissions. The D.C. Circuit gave EPA much broader power to reshape the nation's energy sector, or most any other industry for that matter, by choosing which sources should exist at all and setting standards to make it happen. No tools of statutory construction support that result. First, electricity generation is a pervasive and essential aspect of modern life and squarely within the state's traditional zone. Yet EPA can now regulate in ways that cost billions of dollars, affect thousands of businesses, and are designed to address an issue with worldwide effect. This is major policymaking power under any definition. And though respondents argue EPA can resolve these questions unless clearly forbidden, this court's precedents are clear that's backward. Unless Congress clearly authorizes it, Section 111 does not stretch so far, and Congress hasn't done so here. Second, the words Congress did use in the context where it placed them confirm Section 111's traditional scope. Read together, key statutory terms, like the requirement standards before individual sources and focused on their performance, show that Congress did not greenlight this transformative power. And finally, standing is no reason to avoid the merits. We're injured by a judgment that brings back to life a rule that hurts us and that takes off the books a rule that benefits us. Respondents' arguments sound in mootness, and it's their burden to show that EPA's voluntary cessation and a stay are enough to end the case. They're not. We're asking for the classic appellate relief of undoing what the court below did, and this court has full power to give it. And the weighty issues at stake confirm that it should. In contrast to EPA's important but environmentally focused role, Congress and the states are able to weigh all of the competing factors and constituencies in play. The lower court was wrong to short-circuit that process here, and the court should reverse. I welcome the court's questions.
You start your argument with
You got blueberry oatmeal.
I think we got that.
Take a cherry.
Cherry muffin as well. That we everything for you?
Oh yeah.
Did you want this warmed up?
Yeah, 10 seconds.
The $6.75.
Got a little milk, a little water. Oh,
I added water to that there.
got a little milk.
What's that?
Little milk.
A little milk? I can do that.
Perfecto.
Next, in case 21-248, Berger against North Carolina State Conference of the NAACP. Mr. Thompson.
Mr. Chief Justice, and may it please the court, North Carolina law designates the state as necessary parties, the petitioners as agents of the state, and as necessary parties in all actions challenging state statutes. When such actions are filed in state court, the petitioners are defendants and necessary parties. This lawsuit, however, was filed in federal court, and when the petitioners sought to intervene, they were denied, and a strong presumption was applied against their intervention. This outcome should be reversed for two reasons. First, under Termovich, we are entitled to intervene. The state respondents have candidly and forthrightly acknowledged that they have a primary objective in receiving clear guidance on what law, if any, will need to be enforced. And because that administrative responsibility and interest may not always dictate precisely the same approach to litigation as our interest in defending the law every step of the way, we are entitled to intervene under Termovich. Second, this case presents foundational issues of federalism. This court recently in Cameron held there are deep constitutional considerations implicated when a federal court is called to pass upon the constitutionality of the state law. And thus a